All right, welcome to this week's recap walkthrough of the two lectures that we had for Unit 4. So as always, recommend that you play the recap games on your own first, see how you do, and then come back to this video to sort of walk through the logic with me behind the answers to these recap questions. So let's get started with our recap for Lecture 1. So question 1 is asking you to select from the historical influences on our court system and find those influences that really made use of precedent, right? Using past cases to decide future cases. And as we talked about within lecture, the two that do this are the Justinian Code and the English Common Law. The Justinian Code had the Codex and the Digesta. The Codex was that sort of list of all laws, and the Digesta was basically the transcripts of every case and the notes from jurists. So the Digesta becomes what establishes precedent. And then English common law is completely built around precedent, where judges make the law by sort of looking at how the law has been decided in the past, and that sort of evolves over time. The Napoleonic Code was a strong influence on our court system as well, but not so much for the idea of precedent. It was more concerned with combating inequalities that were present within France at the time, as well as sort of marks one of the first that has wide distribution of the law through the use of printing press. Question 2 is asking you to decipher which type of case gets most seen in our courts. Is it civil or criminal? Now, we spent most of our time talking about criminal courts. However, civil courts tend to have far more cases. And we talked about why that is when we got into Lecture 2 in terms of the issue of plea bargaining, which prevents most cases from coming to the court system and going to trial. So we get far more civil cases through our system than we do criminal. Question 3 is asking about how the appeals process works within our judicial system. We talk about the tiers of the system, and the Court of Appeals specifically designed to sort of lessen the burden of the Supreme Court. But key to this is you cannot appeal based upon a claim of innocence. The only way you can appeal is if you can demonstrate a constitutional right being violated or somehow your trial was unfair. You can't appeal on the grounds that you are, in fact, innocent. The final question for this recap is focused on the Supreme Court and how it conducts its business. When it disposes of a case or decides a case with no written opinion, what is this known as? And so there's a lot of Latin thrown at you within the Supreme Court and just the legal system in general. But when we're talking about no written opinion, we're talking about a per curiam opinion, where they don't have to write anything, they just sort of say, we sort of agree. And they don't sort of expand on why that is. The writ of certiorari is what brings the case to the Supreme Court in the first place. That's sort of the order that the Supreme Court issues to the lower courts to send up everything. Stare decisis is what happens after a case has been remanded to a lower court. So they go back through and sort of see whether the conviction still is being upheld with the Supreme Court's sort of rulings in mind. And then ex post facto is whether those limits of the law we talked about all the way back in our early units. So that's it for the first recap game for Lecture 1. All right, so moving on to Lecture 2, let's jump into that recap. So question 1 is asking you to decipher which pretrial motive, or motions I should say, involves requesting evidence from the prosecution, and it could be multiple answers here within this particular question. But when we're talking about these pretrial motions, the one where we're requesting evidence from the prosecution, we're talking about just the motion for discovery. None of the other motions listed here are requesting evidence from the prosecution. Motion for suppression is asking to exclude certain evidence. Motion for a bill of particulars is asking for the prosecution to outline specifically what behaviors they think the defendant did that were illegal. And then motion for continuance is to delay the start of trial. And so, as I said in lecture, and as I'm saying right now in this recap, make sure you understand what these motions are. It's really easy for me to create questions from these, and I can guarantee you there will be a question on your unit quiz surrounding differentiating pretrial motions from one another. Question 2 has to deal with the issue of being found competent versus insane, and are these the same thing? And so this true-false statement reads, being found not competent is the same thing as being found insane. However, if you pay attention to the lecture, you'll know that that's false. Competency is not the same thing as sanity. So our court operates on the assumption that everyone there is sane until a jury decides otherwise, that you are insane. Being held competent has less to do with insanity and more to do with their being physically or mentally capable of standing trial. Question 3 is asking you to differentiate between different types of alternatives to bail. And so the alternative bail that's asking about here is where you're released if you agree to some court-ordered terms. And so the best answer here is the conditional release. Typically, the conditional release involves the defendant participating in some sort of treatment program or continuing their employment or anger management, some sort of therapy that the court is ordering them to do as we lead up to that trial process. Basically, the court's sort of intervening and saying, hey, I think this defendant would benefit from some pretrial services that sort of may help them in the end. And oftentimes, participating in these to get out of being incarcerated is a good thing for both your case as well as sort of how judges sort of rule on you in the future. If you're sort of willing to make the effort to go through these programs and therapies, then it sort of shows that you're willing to make a change. Final question in this recap is asking you to sort of remember how often plea bargaining happens, and specifically for federal cases. And we talked about really high percentages for both state and federal. At the state level, 94% of cases involve plea bargains, but at the federal level, that number is even higher. It's 97% of all cases involve plea bargaining. So only approximately 3% of our total caseload at the federal level actually goes to trial. And at the state level, it's about 6%. And so we talked within lecture a lot about sort of why plea bargaining happens. So make sure you understand why we have such a high level of plea bargaining as you prepare for your Unit 4 quiz. That wraps up this lecture recap. As always, you can always replay this again as you're studying, and this is a great tool to help you identify some of those concepts that are likely to show up